Justice Gorsuch?
Mr. Schnapper, I just want to make sure I understand, as you say, the statutory language and how this case fits with it. And if we could start with Section 230F4, which defines the term access software provider. It includes, among other things, picking, choosing, analyzing, or digesting content. And we might, in another world in our First Amendment jurisprudence, think of picking and choosing, analyzing, or digesting content as content providing, but the statute seems to suggest that's not what it is. It's something different in this context, in this statutory context, and it's protected. Do you agree with that?
No, and if I might explain why.
Briefly.
I'll do my best. The language that you refer to in Section F4 doesn't apply here.
No, we'll get to that in a minute. But let's just take that as given, okay? That I think that what, say, Google does in picking, choosing, analyzing, or even digesting content just makes it an access software provider. Let's take that as given. And so that would normally be protected activity. But F3 carves out a scenario where you become a content provider, and that's something different, in my mind, to picking, choosing, analyzing, or digesting content. Okay, let's just take those two premises as given.
Okay.
All right? You got to do something beyond picking, choosing, or analyzing, or digesting content, which is what search engines typically do, even as I understand it. You got to do something beyond that. As I take your argument, you think that the Ninth Circuit's neutral tools rule is wrong, because in a post-algorithm world, artificial intelligence can generate some forms of content, even according to neutral rules. I mean, artificial intelligence generates poetry, it generates polemics today. That would be content that goes beyond picking, choosing, analyzing, or digesting content, and that is not protected. Let's assume that's right, okay? Then I guess the question becomes, what do we do about YouTube's recommendations? And as I see it, we have a few options. We could say that YouTube does generate its own content when it makes a recommendation says up next. We could say, no, that's more like picking and choosing. Or we could say the Ninth Circuit's neutral tools test was mistaken because in some circumstances, even neutral tools like algorithms can generate through artificial intelligence forms of content, and that the Ninth Circuit wasn't sensitive to that possibility and remand the case for it to consider it, that question. What's wrong with that?
Well, it's not our theory, but it's, if the alternative is what Ms. Blatt will be telling you, I'll take it.
I'm not asking you, hey,
no, there's nothing wrong with it.
I'm asking you whether that is a correct analysis of the statutory terms you keep referring us to, or whether it is not.
Yes. As we've set out, that's close to something we set out in our brief, which is that the algorithm could create things on its own. It could create a catalog of ISIS videos, which would be analogous to a compilation under Section 101 of the Copyright Act. A compilation is a distinct entity. It's copyrightable, even if the elements of it were not. So, yes, absolutely, the software could create something like that. It would not be third-party content, and therefore it would fall outside the scope of the statute.
Thank you.